Good
Take it
evening.
away.
Good evening, everyone. I'm really excited to be with you tonight. And tonight we're going to be talking, I hope you can see my screen. I think you can. Cancer and your legal rights, 5 legal tips. And first of all, you might hear sirens in the background. I'm sorry about that. It's out of my control. Hopefully there won't be any background noise. But uh, so just getting started, what is the CLRC? So I'm co-director of the CLRC, and our mission is to provide information and resources on cancer-related legal issues to those affected by cancer, whether it's the patient, survivor, caregivers, healthcare professionals, employers, and others coping with cancer. And all of our services are free no matter what. So just even if you have $1 million in your bank account or $0, we don't charge ever. So what are cancer related legal issues? A lot of people are very surprised to know, and you can see that on your screen. Um, they often ask, what does cancer have to do with the law? And here's a list of some cancer related legal issues. It's by no means every issue, but cancer affects the patient, survivor, families, healthcare professionals, impacts many different areas. And if you have an issue that's on that list, or even something that's not on the list, please contact the Cancer Legal Resource Center for more information. I always make this announcement because you never know. The CLRC has a professional panel, which includes lawyers from across the country who help with cancer, those with cancer, if a caller needs help in a matter in their state and practice area. So for example, suppose someone contacts us and they're getting a divorce and they also have cancer and they're saying, how can I make sure, I've young children, how can I make sure that when I speak to the judge, they understand that I could fully assert my rights. There's no concern. So we may be able to refer, for example, if we have a divorce lawyer in that person's particular state, and after we provide resources, we will also refer to someone else who's actually practicing in that area that can help. So we always say, if you know a lawyer, if you're a lawyer and you want to give back, or sometimes you might know a lawyer that's like, gosh, I wish I could give back. I wish I could help. They can contact us and go to that website. So I figure always to get the word out because that can be very helpful for someone affected by cancer that comes to us. So this is our website. If you'd like to view our resources on any number of topics related to cancer, please visit our website. Educational webinars, such as this one, I mean, obviously tonight is recorded, but we do national webinars. And first of all, you can listen to them live when I do them. It's 12 p.m. Pacific. So it's in a sense like during the lunch hour. And if somebody's on the East Coast, it's not too late in the day. And we put them on our CLRC YouTube page. So for example, if you like hearing my voice or you like my presentation, I've done a lot of the presentations for the CLRC, actually by now, most of them. So you can hear about a variety of topics, anything from, advanced planning or health insurance and open enrollment or caregivers, just a variety of topics. You can feel free to check it out. The link to the webinars is on your page too. The great thing about tonight being recorded is that I'm going to go over a lot of information, but you don't have to take notes. That's the great part. You can say, ooh, if you want to listen to a part, you can just forward to that exact part and listen to it. You don't have to take anything down. But at times I might pause if I have a list of something, just in case you do want to take it down, but you don't feel like you need to. If you have a question, I'm going to leave time for questions and or discussion. But sometimes when you're learning something, at least in my case, and as you can see, I've done a fair amount of learning, I don't have a question right away. I kind of need to let it simmer, or maybe I want to ask a more specific question and I want to ask it privately. So that's why I'm putting, you can fill in the online intake or call us, which that's the number on your screen, toll free, and we will provide customized resources for you, do that research and get back to you. So there's no pressure to ask any questions. I'm not at all offended if you don't have anything to say, if you don't have any questions. Just take sometimes a little bit of time to think of something. That's why I also say discussion. If you just want to share a thought at the end, feel free to do so. Finally, and I just make sure to cover ground so that you know after this presentation, there's more and more that you can learn from the Cancer Legal Resource Center. We have a patient legal handbook, And it is, we have one in English and in Spanish. It is available on our website for free. And then if an organization, for example, Pink Lemonade or another, or even a doctor's office, we're trying to get into all doctor's offices, because if somebody's in the waiting room, they could pick up a copy of our free patient legal handbook and read about some common legal issues. One of the most common issues that we get is actually related to employment. We have webinars about that. We have handouts. That's a very common topic that people ask us about. So that the patient legal handbook, it's a really concise guide to some common legal issues and how you might want to think about them. The goal of tonight's presentation, and in a moment, I'm not hiding what the 5 legal tips are. You don't have to wait till the end. I'm literally going to tell you what the 5 legal tips are right at the beginning of the presentation. And then throughout the presentation, I go over each one. So it's by no means guessing, and you don't have to wait till the end to hear them. And my goal in this presentation is not for you to memorize everything or to become an expert, but rather, if you're ever confronted with a situation that any of these legal tips could be helpful, you at least know that there may be a solution out there that can help you. It's just to get your brain to start thinking. Or if, for example, you don't even know where to look and you're like, is this a legal issue or is it not? You can remember this presentation and say, gosh, it doesn't really feel like a legal issue, but there are resources out there, and to know that you're not alone. There's people that really care about having you find solutions and resources. So here are the 5 legal tips. Again, I'm not hiding it. Number 1, it is the patient's responsibility to understand his or her insurance coverage. Number 2, don't take no for an answer. Number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off and keep your job, and to document any end of life preferences, wishes before it's necessary. And now I'm going to break down each of the legal tips and to kind of make it so that we're all on the same page. Some of the information may be fairly straightforward, but that way I make sure to keep it in a framework that we're all informed and know the information. So tip number 1 is the patient's responsibility to understand his or her insurance coverage. So we recognize that it's an impossible task for some patients, but that's how the law is set up. So people make the mistake in thinking that their doctors or surgeons that treat us have to know what's covered by insurance plans or what isn't, and to what extent. And even if the doctor's office says they will call the insurance company to find out, it's always good for someone affected by cancer to become familiar with their plan so that they can understand their copays, deductibles, and networks. This helps prevent unforeseen costs. Read the fine print. You can find information online in some cases if you're working and your company has an online portal, or you can ask your human resources if you are working. But also there are some laws that require insurance plans to cover certain services regardless of whether it's spelled out in the policy. So here are some health insurance options. Of course, having insurance in the first place is one huge step in terms of just even talking about, managing what a lot of people call financial toxicity, the financial effects of treatment, the financial side effects, so to speak. So I'm not going to go into detail on everything on this slide, but just to sum up, there is employer-sponsored coverage, and certainly COBRA. That may be an option if if you're leaving your job or you've lost your job. COBRA is expensive, but can help maintain coverage after employment. For example, if you're really happy with your doctor or the medicines that are covered under your plan, sometimes people just think, gosh, this other insurance plan that, my employer plan is great, my other insurance plan, my doctor's still on it. But a lot of people forget that one huge part isn't just the doctor that's covered. It's also whether the prescription medication is. So if you're happy with your coverage, even though COBRA is an expensive option, you may want to have that if it's really financially worth it. And also, if you're going to consider another plan, make sure that the things that matter most to you, whether it's your doctor, if you're pleased with your doctor, or the medication that you are taking or might want to take is covered, so that you're informed and have the best possible outcome. An alternative and potentially less expensive option, for example, I'm just giving the example with California, but certainly for your state, it would also be, for example, state marketplace, and there's tax credits available. There's also for those, within the state that have disability or have some other financial challenges, Medi-Cal, for example, in California, but Medicare is available for people who are turning 65 or have been eligible for SSDI, Social Security Disability Insurance, for 24 months. And the most important thing I'll mention about Medicare is that we hear far too frequently from people who opt not to sign up for Medicare when they first become eligible due to already having some other coverage or believing the card was sent to them in error. If you're nearing Medicare eligibility, either age or SSDI, please make sure that you fully comprehend the potential downfalls of not signing up during the initial enrollment period. It can lead to severe penalties. For example, every year following the eligibility period that someone does not sign up for Medicare Part B, they incur a permanent 10% penalty added onto their premiums. So if someone delays for 2 years, they will have to pay 20% more premium permanently. However, these penalties don't apply if someone meets conditions that allow them to sign up during a special enrollment period. Here are some Medicare resources. So we're the Cancer Legal Resource Center, so I always try to share some resources. We do recommend Medicare Rights Center and for example, State Health Insurance Assistance Program. And certainly, if you're interested in more specific resources, you can contact our office as well. I'm not talking in this presentation about specific drug options available, but certainly that's something that could be worth exploring for sure. So one great aspect of the timing of this particular presentation is that we're still in the open enrollment period. So if you're looking to purchase insurance through your state's marketplace or healthcare.gov, we are in a critically important time of year. So due to COVID, due to the pandemic, there were additional times of the year that someone was able to sign up. But one of my goals in this presentation, because pandemic protections, they start and then they go away and sometimes they're extended, but I wanted to go over the information that's more kind of the baseline in general, because that's the information that could be useful even if a specific protection goes away. So it's important to keep in mind that you can only purchase or change plans during open enrollment, or if you're eligible for special enrollment period. And for healthcare.gov, open enrollment is from November 1st to December 15th, but some states have their own private online marketplace, while others, of course, use healthcare.gov. Now, as you can see, states that use healthcare.gov, Washington's included. So, and some states have extended enrollment deadlines. So I think that it's, a good idea if somebody is looking to change their insurance to try to get it before that December 15th deadline. So, and certainly, a person can find a little bit more for their state based on that link. Other healthcare options. So if you can't get healthcare, and I understand, people have all different circumstances. I go over this information because sometimes somebody might have great health insurance, but sometimes all of a sudden, a plan's terms may change slightly or their circumstances unexpectedly change. So I think it's helpful to know a little bit more about the landscape in general. If you can't get healthcare, otherwise, here are some options. So private health insurance, although this can be an expensive option, anyone can purchase private healthcare coverage as long as they do so directly from an insurance company or through an insurance broker. Some people are not eligible to purchase through the marketplace due to immigration status or Medicare, Medicaid eligibility. Hill-Burton is a congressional law which gave hospitals and other health facilities money for construction and modernization. In return, these facilities that receive these funds agreed to provide a reasonable volume of service to people unable to pay. The program stopped providing funds in 1997, but about 140 healthcare facilities nationwide are still obligated to provide free or reduced cost care. You can call the National Hotline on your screen to get a list of obligated facilities. Charity care. Many hospitals have free or low-cost care available to someone who's considered low income. So we'd suggest speaking with a social worker, financial navigator, or the patient services at your local hospital department to determine what options may be available. You often have to provide information about your income and other assets. So optimizing health insurance. So if you're insured but concerned about outstanding medical bills, or the best way to use insurance coverage, these tips can be helpful. Here's a couple of things to keep in mind to make sure that you get the most out of your insurance policy. So first of all, you can check your insurance policy to see if it offers a case manager. If your plan or a hospital does not offer a case manager or a patient navigator, if you have a productive, relatively, conversation with someone when you call, ask to speak with the same person each time you call. Positive rapport can go a long way, as the insurance employees may be willing to spend time finding ways to reduce costs. It's, for example, the hospital's case manager that makes sure that someone's health insurance company understands what's happening during hospitalization. So in that case, the person makes sure the insurer has all the information it needs and to approve payment for the hospitalization and to prevent insurance claim denials. So the health insurance company's case manager receives information from hospital case managers, home healthcare companies, physician offices, social workers, and other healthcare providers. It can be awkward to have conversations about costs with your providers, but if at the end of the day, if you can't avoid treatments or prescriptions your provider is recommending, or aren't adhering to the schedule and dosing because of cost, your provider needs to know. They can't help or recommend less expensive options if they don't know your situation. Another tip, keep dates, times, and extension numbers in addition to writing down names. Now, it literally can sometimes feel like a full-time job to speak with an insurance company. I get it. But if there's little things that you can do at the time when you're talking with them to just keep the information straightforward and organized, it can go a long way when you're looking to get something covered. If you're required to get pre-authorization, which is ironic because sometimes you find out you only needed pre-authorization after something is denied, request that it be sent by mail or email and keep it. If you don't get the required pre-authorization for a certain service, it can be difficult to get the service approved later. Open all mail, even if it seems daunting. Review all bills. Compare them with your explanation of benefits, your EOB, insurance EOBs, explain what you owe the provider. Just recently, there was a situation where someone received a really high bill, and it turns out that their doctor's office, which they didn't really go to before very often, just forgot to bill the insurance company. They just forgot. And had the patient not just looked a little bit closer and called the place, they would have been spending for something that their insurance company would have covered, or at least covered part of it. So it's when I read these tips, I relearn it too. So mistakes happen. That example that happened recently. And I'll try to get to talking about any billing errors or medical billing. But let's get on to tip number 2. Don't take no for an answer. This is a life tip, but specifically a cancer legal tip in the area of health insurance denials and disability insurance denials. I'll talk about how it applies to health insurance denials and Social Security applications. If you're denied coverage of a health insurance benefit, you should not take no for an answer. Appeal. Private insurance companies have different procedures for appeals. I'll explain your rights here as it relates to private insurance. If you have Medicare or Medicaid, the procedures are different, but just for the purposes of this presentation, for those with private insurance, the process for completing the appeal should be found in the denial letter. Again, that's why I say read all mail. I totally understand if you're receiving a denial letter, you don't want to look at it any more than you have to. You see denial and you just don't want to even read it because none of the reasons will ever make it okay to be denied. But the denial letter is actually where it says the information to appeal. And and that's the information sent by the insurance company, and should also, and this is really important, contain information about strict timelines that must be followed for a successful appeal. Often medical teams are unaware of insurance difficulties that patients face. So sometimes it's helpful to bring an insurance problem to the attention of your doctor's office and have them call your insurance to explain why a procedure is medically necessary, or they may, of course, send a letter. They can help you appeal or either go another route so you don't suffer as much with the out-of-pocket expense. Also, I would say that even if, for example, time is of the essence and the appeals process can take some time, it's still worth it to appeal, even if ultimately in the meantime, for example, there's another treatment that you'll be doing, still worth it to appeal. Many pharmacies partnered with oncologists are able to advocate for insurance coverage as well and have people on staff to facilitate getting coverage for patients. So if you do appeal your insurance company and they still deny you at the appeal stage, once you exhaust your options within the company, you have the right to an external appeal. An independent medical review or external appeal is an opportunity to have someone besides the insurance company decide whether the company should pay for the service you're requesting. Just by way of example, in California, HMOs and Blue PPOs go to the Department of Managed Care. So other insurance goes to the Department of Insurance unless it's self-funded, in which case the plan must contract with an independent third party. But in most cases, it will go through the Department of Insurance. So usually you have to exhaust the internal appeals process before you can move forward with an external appeal. You might want to just go outside immediately, but unfortunately you have to go through the insurance company through their appeals process. If the situation is urgent, then you may have another way to proceed. So according to the Department of Managed Care, in 62% of the cases, the health plan's denial of service was overturned and the enrollee got this requested medical treatment. Once the case has been decided, the health plan must authorize the services in 5 business days. The independent medical review is relatively, free and easy and fast. And so if one thing to think about is that if you need one-on-one assistance in filing forms, you might be able to contact the Department of Managed Healthcare, and that's that, or the Health and Consumer Alliance. So there are ways. The bottom line is that it's worth it at least to try to appeal internally. If that's denied, to go externally, it's worth a shot. And hopefully these companies will get used to the fact that if they deny it, they're still ultimately going to have to provide it. So obtaining prescription medication. So just to kind of go over this in general, medications must first be approved by the FDA, the Food and Drug Administration. Until the drug is approved, it normally cannot be legally given to anyone except through an approved clinical trial or a manufacturer's compassionate use program approved by the FDA. So compassionate use programs allow a manufacturer to give certain individuals a medication that's being tested in clinical trials before the FDA has made a decision about approving or not approving a drug. So in 2018, the president signed the Right to Try Act into law, which allows patients who've been diagnosed with life-threatening illness, have exhausted approved treatment options, and do not qualify for a clinical trial to nevertheless gain access to medication under a clinical trial if they give informed written consent to the risks associated with taking the medication. When the FDA approves the drugs, it usually is approved for certain conditions or indications. That's what you'll see on the label. Regardless of what the label says, a physician can legally prescribe an FDA approved drug for any reason. This is called prescribing the drug off label. Note that your insurance company still may not approve the coverage just because your doctor approves it for your use. Each plan has a formulary, and that's just a fancy way of saying a list of approved medications. Formulary medications can usually be prescribed without a pre-authorization. The insurance company, not your physician, decides what is on their formulary. Every drug company, or at least many of them, have some kind of patient assistance that you can try to contact to see if you can access that medication. And patient assistance foundations are generally based around diagnosis and have some money. So there's also, there may also be assistance available in some cases for specific diagnoses as well. So Social Security benefits. Another place you don't want to take no for an answer is with Social Security. So just before I talk about denial, I'll introduce the benefits really quickly. So the Social Security Administration is in charge of two federal benefit programs, SSI and SSDI. They have the same definition of disability. You must be unable to work due to a severe medical condition that's expected to last at least 1 year or to result in death. So most people, just to give you a big picture, they'll contact us about an employment issue and they'll say, I need to take time off. So we'll talk to them sometimes about Family Medical Leave Act, or they say, I can go to work, but I need some adjustments. So we'll talk to them a little bit about accommodations. But in some cases, they're saying, gosh, that their doctor is saying due to treatment and recovery, they won't be able to work for longer than a year and their employer cannot keep their job open based on FMLA. And there's no accommodation that really will make it so that they can work. That's when Social Security comes in. So the different laws kind of work at different times for people based on their circumstances. So SSI, so Supplemental Security Income, is based on assets and income, not work history. SSDI, Social Security Disability Income. Social Security Disability Income, disability insurance is based on work history. One must have earned 40 work credits, including at least 20 in the last 10 years. I got a question right now, which is a really good question. If someone is self-employed, usually I won't necessarily take questions just because I want to keep the presentation going and we have so much, but that's a good question. And just to answer it very succinctly, and certainly if you have more details, we can please contact the CLRC if you can go a little bit deeper on that. But generally, if someone is self-employed, they may, and again, it's hard to know someone's specific situation, they may be paying into Social Security just as if they had an employer. It's hard to know that person's specific situation. In that case, they would potentially be eligible for Social Security benefits. But I'll just go over this as well. So Social Security Disability Insurance is based on work history. One must have earned 40 work credits, including at least 20 over the last 10 years. A work credit is currently defined as earning approximately over 1410 in wages, 1,410 in wages, or self-employment income. Again, self-employment. 4 work credits can be accrued per year. And so also one more thing, the Social Security Administration has a blue book, which is a good source to look at for the types of information that can and should be included in an SSDI or SSI application. It lists conditions that SSA has already determined are likely to affect a person's ability to work. So the more that you can focus on conditions that exist, the more that you can make the case that the conditions prevent a person from working, and the better chance that you have an application going through for the first time. Make sure your doctor knows that you are applying. They will know what SSA looks for and will make sure to take appropriate notes that accurately reflect your inability to work. List multiple conditions. If a person has multiple things contributing to their inability to work, beyond cancer, for example, they should list them all. Compassionate Allowances Program. This contains a list of medical conditions that allow for review in days as opposed to months. If your condition falls on the list, you would have to write in compassionate allowances somewhere in the application of benefits. I don't even think that there's a checkbox, which there should be, but just write it somewhere so that they're aware of that. And if you're applying for SSDI, there's still a 5-month wait period. Your application will just be reviewed sooner if you qualify for compassionate allowances review. Now, appeals. Less than half of SSA applications are approved. Most of appealed denials are later reversed. So after appealing, the approval rate jumps to about 75%. The CLRC tip is to appeal rather than reapply. We say don't take no for an answer and appeal rather than apply. And that's because You can be entitled to retroactive benefits. Payments may be retroactive back to the date of your disability began, up to 12 months prior to the date of your application. And if an applicant reapplies, they will lose any retroactive payments. So the appeals process has multiple levels, and there are very specific deadlines to appeal. So there's a bunch of steps, which you know, I won't take time tonight because I want to make sure to get all the information through in terms of what the appeals process looks like. There are SSA attorneys that help with Social Security, and they're actually their attorneys' fees are capped. It's something to explore if that's something you want to pursue. If you feel that you're appealing and you want that assistance from an attorney, but it's not necessary. CLRC tip number 3. Request accommodations before your work performance is affected. I brought up the issue of employment just a little bit earlier in the presentation when I was talking about how different laws come into play and different things at different times are relevant, which is why I truly believe that in listening to a presentation like this, hopefully you'll never have any challenges, but if you do, you'll know that there's some things that are helpful at various times. We get a huge number of questions about employment issues, so I want to cover some employment laws here. It is your responsibility to let your employer know you need help doing your job if you're unable to do so because of a disability, and notify your employer before your work performance suffers. I completely understand and respect anyone's decision if they decide that they don't want to disclose any information to their employer. So that's a personal choice. I completely support whatever the person feels most comfortable. There really is no right or wrong answer. All I'm saying is if you're going to disclose it, we say do it before your work performance is affected. The American With Disabilities Act, a lot of people might not know that the ADA can help those with cancer, as well as your state fair employment agency, work together to prohibit discrimination against people with disabilities, which includes cancer. But it's not illegal to fire someone whose work performance is suffering if they're not doing their job properly. So that's why we added this tip in here. If an employee is not performing the essential functions of their job and the employer does not know about their need for accommodations, he or she can be terminated. So also, just having cancer does not always prevent someone from being fired. I'll explain the ADA and what protections people with cancer do have in the workplace. So this is very interesting. I say all phases of employment because it actually even kicks in if you're interviewing for a job. Okay, so we have a lot of ground to cover. I want to make sure that I get through it and don't hold you guys even a minute over. The ADA applies to state and local governments and private employers with 15 or more employees. I want to just specify that suppose somebody works at a Starbucks that only has 10 employees. I didn't put this on the slide, but it's 15 plus employees within like a certain number of radius. It's either 50 or 75 miles. So the example I give is even if somebody works at a Starbucks and there aren't 15 employees, it's understandable that there's other Starbucks or other whatever chain or whatever office that have other employees. So even if you're looking around and you're saying, gosh, there's not as many employees, that doesn't have to be the end of the story. There could be other locations of the same company within a certain number of a mile radius that would count. The ADA protects employees against discrimination if the employee qualifies for protection. There's two parts of this. So the employee must have a qualifying disability. What does that mean? The ADA's definition is physical or mental impairment that substantially limits a major life activity. Every disability law has its own definition of disability, so know what qualifies for protections under the law. Under the ADA, cancer can be a disability based on this definition. The employee is only protected if the person is a qualified employee. Qualified means the person can perform the essential functions of his or her job with or without reasonable accommodations. In other words, the essential functions of a person's job vary depending on the nature of their work. So an example, an essential function of a delivery person that works for UPS would be lifting over 10 pounds. An office worker might have to lift 10 pounds, but that probably isn't an essential function of the job. If there's no reasonable accommodation that would help someone do the essential functions of their job, and then the employee is not qualified for protection. In other words, your employer isn't supposed to go out of business in order to give you an accommodation. For example, like if there's some accommodation the employer can give the employee to help them do the essential functions of their job, then the employee is qualified. Oh, I just realized instead of scrolling down, I just jumped ahead. But there's no spoilers. Okay, so we were anyway getting to this slide. So if you're a qualified employee with a disability as defined under the ADA, you're entitled to a reasonable accommodation. What is a reasonable accommodation? It's a change in the work environment that enables an individual to perform their job. A change in the physical environment or a change in the policy. For example, the employer's policy might be no eating at desks. We're a lab, no eating at the desk. But maybe that particular employee, and that's the employer policy, but maybe that particular employee who has cancer is going through treatment, their doctor tells them, gosh, in order to feel better on treatment, you have to have a snack every hour or 2 hours. Well, maybe an accommodation could be, this is just an example I'm stating, to be able to have food at their desk, or at least be permitted and not be penalized to briefly take a break and eat that food. So it could be something that's, doesn't cost the employer, millions of dollars, but it makes a big difference in somebody able to do their job. So there's no one size fits all accommodation. The accommodation must be reasonable. You notice I said reasonable accommodation, meeting the individual's needs without it being an undue hardship for the employer. So reasonable for both parties. Another example, if an employee has a standing job like a cashier, but has a disability where they can't stand for long periods of time, it might be reasonable for the employee to ask for a chair where they can take sitting breaks. That isn't really asking a lot of the employer and helps the employee. So then it's reasonable. Or for example, an employee, and this used to be an example that was very kind of out of the ordinary to ask to work from home. But now, as a result of COVID, while it makes it more challenging for people that want to go back to work because of perhaps heightened concerns, working from home may be a more reasonable accommodation now that it's being done more. But it is on a case-by-case determination based on the circumstances of both the employer and the employee. However, if you do plan on asking for a reasonable accommodation, you should do so as early as possible. For example, if somebody, let's say, has a condition that requires them to take more frequent bathroom breaks and just starts taking them, it might mean that a little less work gets done or they're less available. If the employer doesn't know the circumstances, they might think that the employee is slacking off. But if the employee asks for more frequent breaks to accommodate a disability, and you notice I didn't say a diagnosis when I said to accommodate a disability, I just said to accommodate a disability, then the employer is protected from negative action taken by the employer. That's why we suggest asking for accommodation before it affects work performance. Something else that I want to mention is that if you suspect discrimination in employment, I hope no one ever has to go through this, but unfortunately, some people act in ways that we don't expect. Some people may be covered by both ADA and state fair employment law, but before you file a complaint, if that's what you want to do, check with a lawyer. If you're part of a union, contact a labor law attorney. We recommend speaking with a lawyer because in some cases, the lawyer might think you have a good case for a lawsuit, or a lawyer can advise you what agency is the right agency to file with. I wanted to say, just since we're talking about lawyers, I should mention I am a lawyer. I'm licensed in California, in New York, and DC. But this presentation, we have to give disclaimers, is not legal advice. I always say that at the top, and it doesn't establish an attorney-client relationship. I always say that in the beginning. But I was very excited to get started, so I didn't say that. But since we're talking about lawyers, I mentioned it. I am a lawyer. but the goal of the Cancer Legal Resource Center is that we don't take anybody on, we don't represent someone in court, rather we provide free legal resources and do research that will provide someone information that they need that could hopefully help them. So this slide is essentially saying to get some guidance before you make a decision on what action to take. Oh, I just clicked on something that that changed the slide. I just had to adjust it. Sorry about that. In all my presentations, that's never happened before, where I clicked on something, but that's just to show that it is live. And this is the slide that we're supposed to be on. And I just changed the slide on my window. I guess, there we go. Keeps everybody alert when I do technical. Law is my strong suit, but technology isn't. CLRC number 4, we just have 2 tips left. And I'm going to try to move you because I can't even, there we go. I want to be able to hopefully see you a little bit better as I'm presenting. You may be able to take time off and keep your job. You know, I kind of gave a hint as to this when I said FMLA. I'm not about keeping surprises from you. So we do get a lot of questions about employment. And although the American With Disabilities Act prohibit discrimination against people with disabilities, which includes people with cancer, employers are not prohibited from taking negative employment actions against someone if their work performance is suffering or they aren't performing their essential functions of their job and their employer doesn't know about their accommodations. So knowing just another accommodation, sometimes a person just has to take that time off of work and needs to heal properly or go through treatment. So there's something called the Family and Medical Leave Act, FMLA. And I think this is really interesting because it is unpaid and it does give 12 weeks, which can be taken intermittently or all at once. A lot of people think, gosh, I have to take all that time or I lose it. No, it could be taken in increments. It's to take care of yourself or a covered family member. In this, and even though it is unpaid, your job and your health insurance benefits are protected. So it is a federal law, so it applies across the country that gives you the right to take out time off with continued health benefits. It's not a form of income. And if one thing to look at is if your employer is covered. So not all employers have to provide FMLA leave. Government, local, state, and federal employees do, as well as private employers if there are 50 or more employees within a 75-mile radius. So that's where a lot of people run into issues because unless you work for a large enough company or business, FMLA might not help you. You can take advantage of FMLA if you've worked 12 months. It doesn't have to be consecutive. And you have to have worked 1,250 hours in the last year. That averages to about 24 hours a week. So part-time employees may qualify. While on FMLA leave, you are on unpaid leave, but in some circumstances, an employer may require and the employee has the right to choose to use accrued vacation or pay time off so that they can get paid while on FMLA leave. Or an employer may require and an employee has the right to choose to use sick leave when the leave is for the employee's own serious health condition. So if you have 3 weeks of vacation accrued and 1 week of sick time and you're eligible for FMLA, you most likely will not get 16 weeks off from work. Most employees would require use of sick and vacation time concurrently with FMLA, which means the 12 weeks would turn into 4 weeks of paid leave due to use of sick and vacation time, and the rest of the time off would be unpaid. So in that case, the total time would be 12 weeks and some of it potentially would get paid. So if you need more time off, so it just happens where sometimes someone has, it's a predicted time off, but everybody is different and the person might need a little bit longer or a lot longer. So it's important to know that the FMLA can work alongside the ADA. So now we're putting the information that we learned earlier with this information. For example, if you took 12 weeks of FMLA leave, but we're not ready to return to work, additional leave may, and I say may, be granted as a reasonable accommodation under the ADA. So to be protected under the ADA, you must still be able to perform the essential functions of the job as we discussed. If attendance is an essential function of the job, then one cannot be protected under the ADA. So, I think it's certainly a challenge. For example, if someone's a surgeon, that attendance may be an essential function of the job. It's hard to telecommute in for surgery. Whereas, if someone is asking for some additional leave, one thing to help your case is that if there's a definite end to the leave. In other words, saying I need more leave may not be as reasonable for the employer to grant. But if you're saying my doctor at this time anticipates I'll need another 2 weeks of leave, it's different. It's a different employer calculus to say, okay, well, this person has taken 12 weeks of leave. They're on the road of being able to come back to work and they need 2 more weeks. The big picture, it's really, something that we can still manage. Again, I'm just using 2 weeks as an example, but you can see the difference. So, but it is worth to try to ask. Final tip. So no matter what your health, document your end of life wishes before it's necessary. And I think that this is an important topic. We actually have an entire presentation on advanced planning. And there's the way that I think of it is this. It is incredibly empowering, although obviously for anyone, a difficult thing to sometimes think about. Gosh, what do I want in the future? I wish everybody lived forever. So far, that has not been the case. So in any circumstance for anyone, it can be empowering to say, no one lives forever, but there's a way that my wishes can live beyond my years. And even if someone has, like I say, $1 in the bank or $1 million in the bank, it could be worth it and incredibly empowering if someone chooses to do so, to just express what they want to happen if they're no longer here. So advanced planning. I'm just going to go over it in general, just so that you're informed. Basically, there's a person can plan for their property, that wills and trusts and power of attorney for finances, or planning for their health care. Since we're running out of time and I want to leave time for questions, I'm not going to go over advanced healthcare directives and component parts for power of attorney for health. But if you have like more specific questions, you can feel free to ask it during the question and answer period or reach out to the CLRC directly anyway. But I'm just going to go over this a little bit and then I'll leave a few minutes for any questions or discussion. So basically, you may be somewhat familiar with wills, but there are some formalities that need to be followed to make sure that a will is valid, because after all, they want to make sure that, someone else doesn't say that the person has a will when they really don't. There are some certain requirements. And it really varies state by state. Trusts. So you basically, just to kind of really briefly say about wills, some people work with a lawyer. Some people actually, there are online some resources that can help someone kind of more even like fill in the blanks of some things that they might want to include. And I just want to say one more thing also about wills is that some people have pets. And they, that's one thing that sometimes people overlook is that, who would I want to take care of my pet? And I bring this up because sometimes someone might have someone in mind that they think they'd like to have take care of their pet, but a will is a good opportunity to ask that person if they'd be willing to, because you don't know, maybe that person has an allergy you didn't know about, or maybe the person doesn't feel like they can take that on at that time for a variety of circumstances. So I think in a sense, it could be a good template to have kind of just initial questions of just in case kind of an approach. I'm going to get to the question about reasonable accommodation. That question came through. I'll try to get to that in a little bit. So trust. That's an arrangement where a person, such as the grantor, seller, trustor, transfers legal title to a property into a trust for the benefit of another person, a beneficiary, and then the creator of the trust names a trustee who will manage the property and distribute it for the benefit of another person. Also, just one other thing about advanced planning is that if someone doesn't create something that expresses their wishes, the state already has something prepared for that person. So the way that I think about it is like, wouldn't the person rather spell out what they want instead of relying on what the state will say? It's better, there'll be a document anyway, whether it's from the state or from you. So you might as well express what you want. I'm not going to go in detail about this because it's most likely for there's some that you can draft a trust, and then you draft essentially for a pour over will, whatever this trust does not include will be covered by the will. There are some people that consider a trust have a larger estate, but you may be a wise choice if that's something that you'd like to explore for yourself. And oops, again, this is not my night with technology. Passing away without an estate plan. I just briefly mentioned this, and then this is what the state, just for you to know in general. Intestate property is generally first to spouse and children, then to next closest relative to the state if no relatives can be located. And then some banks actually have a form that they would prefer the person use that names a beneficiary. But the bottom line is that I have a hunch that probably the person knows what they'd like to happen more than what the state knows for them. So it's just something to consider. It's difficult for any person at any age in any circumstance to talk about or to think about. So I just figured not to push anyone to do this, but just to provide a different context for if this is something that you want to learn more about, that just some things to consider. And again, we have a presentation about it. Contact the CLRC about it. Power of attorney for financial affairs, just very briefly. So the principal basically gives an agent authority to make financial decisions. It has to be notarized, signed by at least 2 witnesses. And so there are protections in place to make sure that it's just, that document just doesn't appear out of nowhere. There are ways to make sure that it is legally valid. We reached the end, and just to sum up the tips, think about, you learned so much in this hour. You can feel really proud of yourselves, how much ground we covered. Number 1, it's the patient's responsibility to understand his or her insurance coverage. Number 2, don't take no for an answer. Number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off of work and keep your job. Number 5, document your end of life wishes before it's necessary. Now, question time. I haven't left a lot of time for that, but no worries. You can always contact the CLRC by phone or online intake. You don't have to do both. You just choose one. And basically the only difference online, you fill out the online intake yourself. If you call, we ask you those questions. So it might be just easier to fill it out online whenever it's convenient for you. But if you like just talking it out, you can do that too. I'm going to stop sharing. So we did have a question.